The case Engel versus Vitale, I think is how you say it, is about having a prayer in schools led by teachers. And in our history, it has shown that the word God and religion has been used in a lot of places in our government, such as on the dollar bill, it says, "In God we trust." They have a prayer before Congress sessions. In court, you pledge an oath to God to tell the truth, and presidents swear in with their hand on the Bible. So this occurred in New York. Schools had a teacher-led prayer after the Pledge of Allegiance, and it was optional. However, some parents felt that their student would be singled out if they chose to sit down. And so this deals with the First Amendment, and there's also a couple cases that were along the lines of this. The first one was about saying the Pledge of Allegiance and saluting to the flag in schools. That was West Virginia State Board of Education versus Barnett. And some students didn't want to pledge to the flag, and so it was about whether or not they could force them to. And the second one was McCollum versus Board of Education, which was set aside times to teach religion in schools. So they would take the students away from the normal classwork stuff and have them do prayers and Bible sessions, things like that. So those were two cases that kind of dealt with the First Amendment in schools, things like that. For this case, though, for Engel's side of the case, which is the side of the parents that felt their students would be singled out, they said the prayer violates Establishment Clause because since schools are run by the government, it's saying that the government is trying to establish a religion. And it also says that it violates the free exercise for students that don't want to stand up for them to share their religion. It mandates religious training for the teachers that lead it. So if some teachers don't believe in it, they're forced to if it was kept in the schools. And for Vitale, which is the other side of the case for the prayer, says that it shows the religious heritage of our nation. It is a declaration of faith for all religions. So they're trying to say that the prayer doesn't just have to be for Christians. It can be for Jews. It can be for any other religions, things like that. And they said the prayer is voluntary, which is laid out in the facts of the case. And they are saying God is referenced in a lot of other areas of government, like I mentioned in the beginning, like money, Congress, things like that. So why not in schools? So the decision was a 6-1 judge decision for Engel, which was the decision against the prayer. And they said that it violated the Establishment Clause because the government was trying to inflict or put on their religion onto the students. And since schools are composed of government teachers, things like that, it makes it a government program where they can't force religion. And they also highlighted that many colonists left England because England was forcing them to believe certain things. And the colonists came here in hopes for freedom of religion, freedom of speech, all of that sort of things. So they argued that this was kind of just going against what they worked so hard for. And they said that by preventing this prayer, it's not telling students they can't be religious. It's just saying that they aren't going to have a set prayer that everyone has to listen to every morning or be a part of.